The Information Regulator will host a reform to information law dialogue on the 29th of September in Durban in KwaZulu-Natal as part of the International Day of Universal Access to Information commemorative events. This year's program seeks to advance the efforts to amend the Promotion of Access to Information Act and ensuring it is fit for purpose in a digital environment, whilst reflecting on the 25 years since it was brought into effect. For more on this, we're joined now by Alison, Tilley, Information Regulator, South African Commissioner. Alison, good to have you, and thank you very much for your time. In the 25 years of the Promotion of Access to Information Act being in place, how has it worked out, in fact, of fostering understanding in the minds and in the lives of South Africans of this right to access to information, but also understanding the right to privacy sometimes in instances where individuals don't want their information out there, or governments saying this is sensitive information?
Well, I think we've done quite well with people understanding what the right to access to information means, and I think a lot of people understand that they do have that right. I think the difficulty comes in actually making it practical, making it real. And there's been a number of challenges, I think, through from, people using the right form, which sounds very annoying, but it, just legally must have that. And then, through to making sure that people respond to requests for information. And then I think all the way through to once we order the release of information, making sure that the public or private body actually do release the records, because we've now had a number of instances where those bodies simply refuse to act on our orders. So I think it's in some ways, it's not where I expected us to be. Let me say that. I think that I had imagined that there would be much more of an understanding of why transparency is important, how releasing information assists all of us in a democracy. And I think we're still seeing people really hesitating about releasing information, also because of privacy concerns. But frankly, I think in a lot of instances, people use privacy and use POPI as a way to avoid the requirements of the prior legislation and the right to access to information.
Yeah, we're talking theme of reforming the information law dialogue that is taking place, I think, on Monday, or at least sometime in the week that is coming. Now, the Dula Omar Institute, for example, when it comes to municipalities specifically, would have argued the fact that you have to apply to get the information as a barrier to hide information. Are these some of the areas that could be better improved?
Yeah, no, I think we've really come a long way in terms of proactively trying to make sure that people release records. So we've been doing audits of PIA compliance and making sure that people have their PIA manuals up on their websites. I think people sometimes don't really understand the importance of that. They think of it as just a sort of mindless bureaucratic exercise, but it's intended to give people the roadmap to where the information is that they want, and also the very practical things that you need. Who is the information officer? What is the the email address to use? What is the form that you need to fill in? And I think once we have those in place on more websites, that will also assist us to make sure that it's not just a bureaucratic exercise, that in fact you are able to request information and then have that request responded to quickly. That's the other thing that I think we are seeing, is that there's a delay in response, whereas it should be as soon as as possible, as soon as the information is available. Some people think that you have to wait 30 days, but that's not correct. You're entitled to the information as soon as it's to hand. Certainly after you've not made the information available after 30 days, it's deemed a refusal, and the requester can then proceed with the rest of their remedies without coming back to you as the record holder. So I think we've got some work to do in terms of getting those things ironed out, and just people knowing what the details are.
Yeah. What has been the regulator's realization of some of the issues in implementation, particularly in a digital age where, you know, news now break on social media spaces before they even get to us here on television?
And I think that what we see is as always, I suppose, the rich get richer. And the poor get poorer. So people who have access to information through, you know, their Wi-Fi at home, they've got Wi-Fi at work, they've got data on their phones, they go to shopping malls where Wi-Fi is available, the information is at their fingertips. Where you're not in that situation, and most of our country aren't, you then have the difficulty of having to go online, pay for data, and we know that data is expensive. There are all of these initiatives to try and make sure that people do get access to data through libraries, through municipalities, and that's really work that's very, very important and that has to continue. And we really have to keep doing that to make sure that those people do get access.
Yeah. So coming out of the dialogue, I mean, what type of information do you expect would emerge there that could help improve in those areas to strengthen this particular constitutional right to access to information?
I think the only way we're going to be able to improve those things is to make sure that we have, a situation where we have people who can get access to information more quickly, and that we just are able to do that more easily.
That's Alison Tilley. We appreciate your time. Thanks so much for joining us there, Alison Tilley, Information Regulator at the South African, at the Information Regulator South Africa.